Court is calling 2021 CR 7498, State of Texas versus Jacqueline C. Sanchez. Can I have parties announced for the record for the state?
Daniel Escobar for the State of Texas.
Defense?
Karen Corey for Jacqueline Sanchez, defendant, Your Honor.
Are you Ms. Sanchez?
Yes, ma'am.
Let me show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jacqueline C. Sanchez who was placed on deferred adjudication in 2021 CR 7498 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on December 10th, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2, on or about the 12th day of February 2024 in Bexar County, Texas, the defendant, Jacqueline C. Sanchez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True, ma'am.
Before this hearing begins, there is critical background context that makes everything about to happen in this courtroom significantly more serious and more layered than a typical probation violation proceeding. Jacqueline Sanchez was originally placed on deferred adjudication for possession of a controlled substance in a quantity ranging between 4 and 200 grams. That is not a minor possession charge sitting at the bottom of the scale. That quantity puts this case squarely in a range that suggests distribution level amounts rather than simple personal use for oneself. She was given 3 years of deferred adjudication and referred to felony drug court, which is one of the most intensive structured and resource-heavy intervention programs available anywhere in the Texas court system. Felony drug court involves regular appearances before a judge, frequent drug testing, mandatory treatment programming, accountability meetings, and a level of supervision that goes significantly beyond standard probation reporting. She completed the main drug court program. She graduated. That is a genuine and documented accomplishment that takes real sustained effort over an extended period of time. And then during the aftercare reentry phase that follows graduation, everything started falling apart. And what comes out during this hearing about what was found on her phone when a search was conducted is what transforms this from a difficult but manageable probation violation into something the judge cannot look past.
Your Honor, state we resolve the violations.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 2? All right, you're whispering.
Yes, ma'am.
All right. Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor, it's for 2 years TDC.
That is our proposed agreement, Your Honor.
All right, why should I give her the minimum? What has she done on probation?
Judge, I can tell you that she did complete drug court. Unfortunately, she kind of fell short in reentry court. She had tons and tons of negative UAs. She had been working really, really hard. I believe that the underlying offense was 7 grams, so I know it's 4 to 200, but it was closer to the 4 than it was to 200.
Watch very carefully how this moment unfolds, because the explanation being offered to this judge is about to change direction in real time, and each new version of the story reveals something more significant than the one before it. She started by telling the judge she was removed from the reentry program because she could not afford to pay for her drug tests. The judge pushed back on that immediately and with specific knowledge, because felony drug court programs are specifically designed to accommodate participants who cannot afford testing fees. Financial inability to pay is almost never on its own the reason someone gets removed from the program. So the answer had to change. And it did. She had a relapse. She drank 4 beers on a specific date. But the judge kept pressing because drug court programs are also specifically designed to understand and work through relapses as a normal and expected part of the recovery process. A single relapse involving 4 beers is not typically what gets someone removed from a program they have already completed successfully. So the judge asked again. And that is when the real answer finally arrived. She told the judge that the program felt like she had played them, that she had been lying to them. And the judge stopped and asked specifically what that actually meant. Because the difference between a relapse and deliberately deceiving the program designed to help you is not a small distinction in a courtroom like this one.
And Judge, she does have, I think, 139 days in jail. She just really just wants to put this behind her and move on with her life. She tells me she's been working for 2 years at the Tower of Americas. She's hoping they'll keep her job open for her, depending upon how, if you follow the recommendation, how long it takes for her to parole. She's got a house that she bought. Her kids are living in it. They've been paying the rent. She's hoping that will sustain itself while she's gone. But Judge, she just wants to put this behind her and move on. But she did do a significant amount of work on this probation.
And right here in this single moment, everything that has been established in this hearing up to this point changes direction completely and permanently. She just disclosed that in addition to trying to locate methadone for a friend who had relapsed and was supposedly trying to get clean, she was also separately attempting to find marijuana for someone else who had reached out and asked her to source it. And she mentioned it with a qualifier that suggests she believed it would soften the impact. She said she never actually completed that transaction, as though the fact that the deal did not go through somehow changes the nature of what she was doing in the first place. But stop and think carefully about what she has just described to this judge in open court. She was actively enrolled in a felony drug court reentry program, a program that exists for one specific purpose, which is to keep her connected to sobriety and surrounded by accountability and support structures designed to prevent exactly this kind of behavior. And during that exact same period, she was using her personal phone to reach out to contacts and attempt to locate illegal substances on behalf of other people. That is not a person who had a momentary lapse in judgment during a difficult stretch of recovery. That is a person who was actively participating in drug sourcing activity while under the direct supervision of a specialized court program. And the judge heard every single word of it without interrupting once.
All right. You want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
The judge just made what is arguably the single most legally and philosophically significant statement in this entire hearing, and she delivered it in 5 words that arrived with complete and unmistakable finality. You made choices. They are not mistakes. That distinction is not semantic. It is not a matter of tone or emphasis. It is a foundational principle of how accountability works inside any legal system. The word mistake carries a specific and meaningful implication. It suggests something unintended, an outcome that occurred despite a person's genuine efforts and best intentions, something that happened to them rather than something they actively chose to bring about. The word choice implies something entirely different. It implies agency. It implies awareness of the options available. It implies a decision made by someone who understood what they were selecting and why, and who selected it anyway despite knowing what was at stake. Searching for illegal substances for other people while enrolled in a specialized court-supervised reentry program is not something that happened to this defendant by accident or through some failure of circumstance beyond her control. It is a series of deliberate and documented decisions made by someone who was under active court supervision, who had already completed the main drug court program, who knew exactly what the conditions of her participation required, and who chose to do something directly contrary to all of that anyway. The judge is not being harsh when she makes that distinction. She is being precise. And precision matters enormously when 6 years of someone's life is sitting on the table.
Yes,
All right. You can lower your hand. State your name for the record.
Jacqueline C. Sanchez.
All right. Why didn't you do well in drug court?
I'm sorry, what was that again?
Why did you not do well in felony drug court?
I didn't have the money to pay for the UAs, ma'am.
No. Felony drug court usually will not remove you from their program because you can't pay UAs. Are you telling the court that you were removed from felony drug court because you couldn't pay for the UA?
And I had a relapse. I had drank 4 beers, ma'am.
She actually graduated from drug court, I believe, and then she went to the reentry. So I think she completed drug court. So I don't think she had a problem doing drug court. I think it's when she got out.
So here's my question. Why did they remove you from their reentry program?
Because I drank 4 beers, ma'am, on the 23rd.
No, usually it's more than that because felony drug court usually understands relapses. Am I wrong in that? Did they not understand that you had a relapse?
They usually do, ma'am, but this time they felt like I played them.
What do you mean by they felt like you played them?
They felt like I was lying. I lied to them.
Okay. All right. Probation.
Judge, the note that was received from the drug court was.
Well, just one second. Any objections to probation giving me some insight in whether or not I should follow this agreement?
Okay.
And also, they found on my phone that I was trying to get, methadone for a friend because he relapsed and he was trying to get clean, and that's what I was doing. And I had somebody else ask me I was looking for marijuana for somebody.
Wait a minute, what?
I was looking for marijuana for somebody. They asked me to look for it. They text me if I could find it, and I told them yeah, but I never got to doing that.
Oh, so now we're getting to the point. So you were in felony drug court in the reentry program, and you were looking for drugs for other people.
Judge, I think she was looking for methadone and possibly marijuana. She's not, the perfect probationer, but that's what she told me, Judge. I don't think it was.
I made a mistake, Judge. I'm sorry about that.
Nope, you made choices. They're not mistakes, they're choices. All right, is there anything else?
Judge, again, we just ask that you consider the fact that she did spend a lot of time in drug court. She has been straightforward with you, I believe. And ask you to follow the state's recommendation of 2 years TDC.
All right, and do you want me to hear from probation or no, counsel?
Sure.
No?
I don't think my client's trying to hide anything, Judge.
Okay. Probation?
The information that was received from felony drug court was, she did finish the program successfully. However, during the aftercare portion, there were UA tests with positive ETG results, and a phone search was conducted and text messages revealed that he was communicating with negative contacts and negotiating the sale of illegal drugs.
Okay.
I did reach out to felony drug court to see if they would be willing to accept for that, and at this point they are not.
All right, so this is what the court is going to do. As previously stated, the court is finding violation of condition number 6 true.
So I think it's
I'm sorry, number 2 true.
Yes.
Thank you. The violation of condition number 2, the court is finding that to be true. There's a $1,000 fine. Time and money will run concurrent. Was the $57 ever paid for the laboratory testing? Do you know if you ever paid that?
Drug court? Was it okay. No, I have not taken it.
Okay. There should be $57 restitution to SAPD for laboratory testing. If you would like, I could have you referred to the therapeutic community. It doesn't increase your time at the prison. It's just something to hopefully help you maintain your sobriety.
Okay, I'll take that.
All right, therapeutic community. Court's going to sentence you to 6 years in prison and give you credit for any time served. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? Did you review that with your attorney? Did you understand it? Did you review that document with your attorney? Did you understand it?
I'm just leaving it to me right now.
Okay.
I explained to you. So you have one of the documents. You understand this?
All right. Did you review that document with your attorney? Did you understand it?
Yes.
All right. Because this is not, I did not follow your proposed agreement with regards to sentencing. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? And you need help? You feel as though that's not being addressed, so you don't know who to contact? Felony drug court is always available, okay?
Okay. Thank you.
Okay, thank you. Good luck to you. All right, who's here on Christopher